Two explosive court cases shake up the federal government. In one case, 24,000 employees are brought back to work. In another, Elon Musk is given 3 weeks to provide documentation on what Doge does and what its plan is to clean up the federal government. Stay tuned to learn about each case. I have my notes here, so I'm going to refer to them as I'm talking about this video, because these are some important cases. The first case we'll look at is dealing with the 24,000 probationary employees who Judge William Alsop of the U.S. District Court for Northern California said were fired based on false claims of poor performance. And he ordered the immediate reinstatement of these employees. These employees are from these 6 major federal agencies: Veterans Affairs, the Treasury Department, Defense, Agriculture, Interior, and Energy. The judge also left room that he may expand the order to cover other agencies. Now, why did Judge Alsop declare these firings unlawful? Well, he said they were based on false and misleading information, basically on poor performance, where some of these employees had actually been given outstanding performance ratings. Basically, the Office of Personnel Management, or OPM for short, ordered the agencies to fire these probationary employees and in fact sent the probationary termination notices. And in those notices, it cited the reasons for the firings: poor performance. But again, some of these employees had excellent performance ratings. Also called the firings, and I'm going to quote him, a gimmick to avoid reduction in force or RIF laws, unquote. He also stated it's a sad, sad day when the government fires good employees under false pretenses. He even went on to accuse the DOJ lawyers and OPM officials of dishonesty in defending the case. That's some harsh words from the judge. Multiple high-ranking officials from the agencies affected actually testified and contradicted the claims of DOJ and OPM. For instance, Jeffrey Grant, a CMS official, stated the fired employees were, quote, best of the best, unquote. Tracy DeMartini, former IRS HR chief, stated OPM directly ordered the firings without considering performance. The judge also called out DOJ for defying court orders. Let's see what this is about. The Justice Department refused to bring acting OPM director Chuck Easel in for testimony. And mind you, this case, let me go back. This is AFGE versus Easel. That's the American Federation of Government Employees, that union versus Easel, and Easel is the OPM director. Judge Alsop called the refusal a sham, and that was his direct quote, a sham, and ordered OPM advisor Noah Peters to sit in for 3 hours of deposition. DOJ tried to argue the agencies fired workers independently, but the judge cited multiple agency statements confirming OPM's directive. So although DOJ is saying the agencies made the decision to fire their probationary employees, the judge found evidence that it was the exact opposite. They did so because OPM told them to. So what happens next? Well, federal agencies must reinstate all the affected employees immediately and inform them of the court ruling. I'm pretty sure people know about this already. OPM is now prohibited from issuing any further directives regarding probationary firings. The case could expand to include other agencies, leading to more reinstatements. So what's the big takeaway from this court ruling? 1, the federal government was trying to circumvent federal workforce laws. The judge talked about reduction in force, or RIF. Those are laws that govern how agencies can legally downsize employees. You have to have justification based on budget constraints, reorganization, or other structural reasons. A structured process that includes seniority, job performance, and reassignment considerations must be used. You also have to give advance notice and opportunities for appeal for affected employees. By labeling determinations performance-based instead of a mass layoff, the administration avoided those legal requirements. This is the judge stating this in the decision. This is not my opinion. This is the judge's opinion. thus making the firings easier and faster. I'm just summarizing what he said. Basically, probationary employees in the federal government serve 1 or 2 years in their probationary status, and they have fewer job protections than tenured employees, but they still have rights under federal law. Now, if the agencies had actually followed the reduction in force or RIF, the employees would have had a right to be reassigned to other positions. They also would have had access to appeal and review processes and severance benefits or priority hiring status. The judge said by falsely claiming poor performance, the administration denied those legal protections to the probationary employees. And what I found really striking was the judge's accusation of dishonesty. He directly accused the government of lying to justify the firings. The ruling suggested that the government knowingly misled the public and courts by using a fabricated reason instead of admitting to workforce reductions. Basically, when they were saying the probationary employees were being terminated due to poor performance, when in fact that wasn't the case, they were lying. That's some strong language from the judge, don't you think? The judge also pointed out some fired employees, like the agriculture department worker, had received only outstanding performance reviews, proving that the terminations were not performance-based. This case also sets legal precedent. This ruling establishes that agencies cannot manipulate legal definitions to bypass established workforce laws. It sends a strong warning that similar unlawful employment practices in the future may face legal consequences. Do you think that's the case? Do you think the Trump administration is going to abide by this court ruling? I think Trump has hinted in the past few weeks that if he has to, he's going to disobey a court order if he believes that's in the best interest of the nation. So do you think he's going to abide by this order and bring back all these employees? Leave a comment, let me know. And let me know your reason for your comment. In a big tell in this decision, the judge used this phrase, quote, gimmick to avoid RIF loss, unquote. That's key because that captures the core issue of deception in this case. This shows that the firings were not just political or administrative, but a deliberate effort to sidestep legal safeguards for these employees. This is why the judge ordered immediate reinstatement and suggested expanding the ruling to other agencies. This is a major victory for federal employees and government accountability. It sets a legal precedent that even probationary federal workers have rights and that government agencies must follow proper procedures. Now, I believe I stated in last week's vlog, I do believe there's fraud and waste and abuse in the federal government by both major political parties, Democratic and Republican. I also believe that it's probably time for civil service reform. The last reform was under Carter in 1978. But until that reform is done, I truly believe, and I guess Judge Alsop is pretty much laying it out, there's rules and regulations that have to be followed. And he's saying that the Trump administration didn't follow them in firing these probationary employees. What do you think? Do you agree with the judge, or do you agree with the way the Trump administration and Elon Musk and Doge went about terminating these probationary employees? And if you're one of these probationary employees, when your agency contacts you, what are you going to do? Are you going to come back to work? Because I think some of these probationary employees were terminated around Valentine's Day. So that's been almost a month. Are you going to come back to work? Are you going to feel safe in your work, in your job, I should say? I mean, do you think you're going to get another email or letter or however you were terminated, that you're terminated again? Let me know in the comments. Now, let's talk about the order that Elon Musk was given to provide information on what exactly Doge is doing, basically to show some receipts for what it's done and what's its plan for, helping the federal government, basically. So this case is, let's see. Oh, the name of this case is State of New Mexico versus Elon Musk. This is the one where I believe there were 14 different state attorney generals that went after Musk and Doge. in Trump administration? The judge there has ordered Elon Musk and the Department of Government Efficiency, or DOGE, to turn over key documents and answer written questions about their role in downsizing federal agencies, firing employees, and suspending contracts. This is a win for 14 Democratic state attorneys general who argue that Musk has wielded unconstitutional power over government operations. The decision could determine whether Musk's involvement in federal restructuring is blocked entirely. Do you agree with this decision thus far? Do you think Musk is going to abide by it? He's going to answer and provide the information. Let's go into a little bit more detail. Judge Tanya, I think it's called or pronounced Chutkan. It's Chutkan. I'm sorry if I'm mispronouncing your name. She was appointed by Obama, and she's the one that ruled that Musk and Doge have to turn over the documents, and they're given 3 weeks to do so. The goal is to identify Doge officials Musk has placed in government roles and clarify the extent of Musk's authority in shaping federal policies. And I think that's fair. He's doing all this to clean up the government. Let us know exactly what your role is. Show us the receipts for the work you're doing. Show us the plan for the work that you're doing. Now, what's key about this one? Well, one of the key things, this is the first time that Musk has been ordered to provide documents in a lawsuit challenging his government activities. Before this ruling, he's been doing whatever he wanted to do and being unchecked. And for a while, either he wasn't running Doge or he was. It was Amy Gleason or it was him. So maybe now we'll know one way or the other. Now, the Trump administration has tried to shield Musk from legal discovery, arguing that he's a senior White House consultant, a senior White House advisor, and therefore protected under executive privilege. Now, just about every past president has argued that with some of their senior advisors, so that's nothing new. But Judge Chutkan ruled that the requests were narrow and would not overburden the executive branch. So she says, okay, you may have executive privilege, but I'm not asking you for a lot of information. I'm asking you for a little bit of information and you can provide it. Trump himself does not have to answer anything. This is only for Musk and Doge. So what's next? Well, he's supposed to, and when I say he, Doge and Musk are supposed to provide the documents and responses within the 3 weeks. The discovery process could reveal how much authority Musk actually holds over government agencies. If Musk fails to comply, further legal consequences or court sanctions could follow. What do you think that will be if he does fail to abide by the order? That'll be interesting, won't it? This case could also set a legal precedent for how much influence private individuals like Musk, especially billionaires, can wield in the federal government. Now, here's 5 points about this particular case I want to make. Legal oversight over Musk's government role. Again, this is the first time that a judge has forced Musk to provide documents basically saying, what is your role in federal government? What is your role over federal agencies? 2, limits on executive privilege. The Trump administration tried to block this legal discovery, but the judge said, again, this is a narrow request. Your executive privilege doesn't apply here. 3, potential to block Musk's government involvement. If evidence proves that Musk has violated constitutional limits, the court could completely block his influence in federal government operations. Do you think that will happen? Do you think if it does happen, that the Trump administration will abide by the court rule? 4, this sets a precedent for private influence in government. This case raises major legal questions about how much power private individuals, especially billionaires, can wield over federal agencies. Do you think such people should even have any influence over federal agencies? 5, more legal battles ahead. This is just the beginning, I think. Doge and Musk must comply within those 3 weeks. but further legal challenges or appeals are likely. In fact, more courts are already enforcing transparency around Musk influence, with another ruling requiring Doge to review thousands of documents for a FOIA request, Freedom of Information Act request. This case is about legal accountability for Musk and for Doge. It signals that executive privilege has limits and that courts are willing to challenge private sector influence over government agencies. What do you think about those two cases? The first one with the probationary terminations and the employees being immediately reinstated, was justice served there or not? And the second one with Musk. Should a private individual, a billionaire or not, have any kind of influence like that over the federal government? What do you think about each ruling? And again, do you think the Trump administration's gonna comply with the court orders? Do you think Musk will comply with the court orders? If they don't, what do you think will be the next steps? Let me know in the comments. Thanks for watching this blog for this week. It's been a crazy week in political news, that is. In the taping of this video, we still don't have a budget. So, will we have one or not? The current continuing resolution ends tomorrow. What do you think about that one? See you next week. All the best.